Court is calling 2025 CR 006778, State versus Paul Marino. Can I have the parties announce?
Lauren Espinoza for the state.
Jay Rich, Your Honor, for Mr. Marino.
And are you Mr. Marino?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Marino, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Wait, this is a major development. The prosecution drops the drug-free zone enhancement and proceeds on possession under 1 gram. That move significantly lowers the sentencing exposure. This is plea negotiation strategy unfolding in real time. So what's your take? Calculated defense pressure or the state tightening up a shaky charge?
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor. State moves to waive the drug-free zone enhancement language and proceed on the lesser included offense of possession of a controlled substance, PG1 less than 1 gram.
Any objection?
No objection, Your Honor.
Just one moment. All right. Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading? I'm sorry, you already waived the reading of the indictment. There's a lot happening on my computer where screens are disappearing. All right. Mr. Marino, did you review the admonishments with your attorney? Did you understand it?
Yes, Your Honor.
And did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with possession of a controlled substance, penalty group 1, less than 1 gram as a state jail felony? Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. Did you understand by entering this plea, you're giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
No, Your Honor.
You're giving your right up to go to trial and
Yes.
enter a plea.
Yes, Your
All
Honor.
right. Did you intend to give up those rights I've explained to you?
Yes, Your Honor.
And are you entering this plea freely and voluntarily?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
In my opinion, he does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Marino, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry into the United States. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, the state is proceeding on the lesser included offense of possession of a controlled substance, penalty group 1, less than 1 gram. They're asking that your punishment be assessed at 29 days in the Bexar County Jail under 1244, and there's a $600 fine. Did you understand that to be the plea?
Yes, Your Honor.
Did you understand if you are seeking to enter into an agreement where your judgment is satisfied, the court can only sentence you to the 29 days if I follow your plea, whether or not you're receiving 2 for 1 or 3 for 1 at the jail? The court has no jurisdiction over that. Do you understand?
Yes, Your Honor.
All right. And defense is at the plea?
It's plea, Your Honor.
State is at the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Your Honor.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
It's up to you. Guilty or no contest.
Which one?
You can either one of them. You know what you did.
All right, here's the thing. If you plead no
Here's where the decision gets tactical. The judge clearly outlines the difference between a guilty plea and a no contest plea. No contest doesn't admit guilt outright, but it also doesn't fight the charge, and it can limit certain civil consequences. At this stage, it's less about proving innocence and more about controlling fallout. Would you secure the deal or gamble at trial?
contest, that just basically means you're not fighting the charges against you. You're not saying it's true. You're not saying it's not true. You're just not going to fight the charges against you.
All right.
Usually people will enter into no contest pleas because sometimes there are collateral consequences. For example, if you're charged with a criminal mischief, or if you're charged with a DWI or an offense that causes an accident, sometimes there are monetary amounts that are owed. For example, if there's a car accident, maybe that person is saying, because of this car accident, I suffer $6,000 in damages. If you plead guilty to that, they just take that over to the civil court, and the only issue for you to fight over that will be the amount of money. That's normally why people plead no contest. But what I can tell you, if there's no application for deferred adjudication, if you plead no contest and I find that the evidence is sufficient to find you guilty, I will find you guilty. The no contest plea is just something that can be used on the civil side against you. Do you understand?
Yes.
And a guilty plea is exactly what it says. If you enter a plea of guilty and if there are some civil penalties that are associated, they can go over to civil court and just take your guilty plea. You understand?
Yes, Your Honor.
So do you wish to plead guilty or no contest?
No contest.
All right, state any evidence.
Yes, Your Honor. State offers State's Exhibit 1 and all attachments.
No objections.
All
Your
right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. After reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
All right. How long have you been using?
Like 3 years maybe.
All right. Do you have any family support?
Yes. Before they had arrested me, I was staying with my mother, and I just talked to her a couple of days over the phone, and I told her if they let me out, would I be able to go back to the apartment? She told me yes, Your Honor.
And what were you doing living underneath the bridge then?
At that time, I was homeless, and I didn't have a job. And after I had got locked up for that, and I PR bonded out, I started working at temp services here and there, and my mom let me stay with her, doing side jobs.
So when's the last time you used?
Last time I used was the last time they arrested me recently.
And what have you been using?
What I have been methamphetamine and marijuana.
All right. The court is going to find you guilty, sentence you to 29 days in the Bexar County Jail under 1244, give you credit for any time served. There's a $600 fine, time and money to run concurrent. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Here's the thing. You have a
And suddenly the courtroom shifts from procedure to personal reality. The judge addresses the addiction directly, warning about the cycle of jail and the potential consequences beyond it. That's not theatrics. That's a blunt intervention. Sometimes the most powerful moment in court isn't the sentence itself. It's the warning that comes with it.
drug problem.
Yes, ma'am.
And just going to live with your mother, that's sort of like avoiding your problem. There are plenty of inpatient treatments that you can go to, which you probably need inpatient treatment.
Mhm.
Otherwise, what's going to end up happening is you're either going to end up back and forth in the jail or in the prison, or either your mom is going to have to identify your body. When you're released from jail, if you can't find a place for inpatient treatment, you come back here, I'll pick up the phone and find a place for you. Do you understand?
Yes, ma'am.
All right, good luck to you.
He has 29 days in custody, Judge.
Okay,
All
a
right.
total,
Yes,
then that'll be a judgment satisfied.
I verified that with the clerk here,
Okay,
then she can verify that.
all right, thank you.
Thank you.
Thank you, Your Honor.
You're welcome. All right, the court is calling 2024 CR 011624, State versus Jan Hawkins, AKA Jan Madura. Can I have parties announced?
Chandler Bowen for the state of Texas.
Linda Corley for Ms. Madura.
And are you Miss Madura?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Off the record for a moment. So they have her AKA is Jan Madura, but that's her name, correct?
The case was originally submitted as Jan Hawkins.
Okay, but shouldn't Jan Hawkins be the AKA and not Jan Madura?
I think as long as they're both there, it's okay. Is my understanding.
Okay. Because all of the other paperwork doesn't have an AKA listed.
We don't have any objection to that, Judge.
All right, we're back on the record. Did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, Your Honor.
And are you Jan Madura?
Yes, Your Honor.
All right. And you're not Jan Hawkins, correct?
No, Your Honor, I'm Jan Madura.
Thank you. Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor. We are waiving count 1. We're proceeding on a lesser included of count 2
And what are you proceeding on?
on a Class A theft.
No objections, Your Honor.
All right, did you review the court admonishments with your attorney? Did you understand it?
Yes, Your Honor.
And did you sign it in electronically sign it in all the appropriate places?
Yes, Your Honor.
Did you understand the state is proceeding on the lesser included offense of theft, $750 up to $2,500 as a Class A misdemeanor? Range of punishment is anywhere, it's up to 1 year in the Bexar County Jail and up to a $4,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. Did you understand by entering this plea, you are giving up those rights?
Yes.
Did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 1 year in the Bexar County Jail and up to a $4,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
She has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Miss Madura, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes. Your Honor.
Did you understand by entering this plea, if you're not a U.S. citizen, you will be deported, denied naturalization, and the right to re-enter the United States?
Yes. Your
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, the state is proceeding on the lesser included offense under count 2 of theft, $750 to $2,500. They're waiving count 1. They are recommending deferred adjudication. They say that you've paid $1,077.01 to the Junior League of San Antonio. And I'm assuming there are no other outstanding restitutions.
There's one that we've got on there below the line, Your Honor. There was an insurance claim that was made by the complainant by Berkshire Hathaway. It's reflected toward the bottom.
All right. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Your Honor, we understand that we can address the court on the any restitution to third parties, but yes, other than that, it is our agreement.
State, is that the plea?
That's the plea, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 2 years. They're recommending restitution to Berkshire Hathaway in the amount of $9,799.42 and $227.71 to Visa. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the offense, the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
We'll offer Exhibit 1 with all attachments.
No objections, Your Honor.
All right. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea, that means that the state will be presenting witnesses in the form of witnesses' statements and police reports, but there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations.
Your Honor, if I may, we did make an amendment to the stipulations in concert for agreement with the ADA. We have marked out we're not saying that all the stipulations are true and correct. We have a controversy on the amount, the final amount. So
I think the issue, Judge, is that if you're intending to impose the restitution to Berkshire Hathaway and Visa, they're going to ask for a restitution hearing. Is the main issue here.
Well, I am going to ask.
Now the tension rises. The defense pushes back on the restitution language, but the judge draws a firm procedural line. You can't challenge the core evidence and still expect the plea to stand. If there's no clear stipulation, there's no deal. This is courtroom precision under pressure. Is this smart advocacy or unnecessary risk?
To a restitution hearing. And the fact, these stipulations, you can't just cross out that you're not stipulating that the evidence is true and correct because you haven't stipulated which party you're saying is not correct. When you cross out the stipulations, then you're saying we're not stipulating to any of it. So y'all will have to correct your paperwork.
Judge, if I may, we've done this before. We are
Not with
pleading
me.
Actually, I have on one prior plea on a case that was a family violence case, Judge, in this court. But we are pleading no contest, which means we don't necessarily agree, but we're not fighting about it, which is provided in the law for that purpose. Having us we've also marked out judicial confession and changed it to no contest.
Oh, you can change all of that to no contest, but you can't change what you're stipulating to, because otherwise she's not even stipulating to the fact that she owed $1,000 to the Junior League.
Well, Judge, she doesn't have to stipulate to her. She's pleading no contest. And so that is the plea that's provided in order for people who disagree with what's being said to be able to move forward with a plea. I've never had a problem with that before. I've done it in this court.
No, I tell you what has been done. There has been, with regards to the indictment that's a part of it, where you say, I am not contesting anything, and you take out the judicial confession but the evidence is the evidence that is presented. And then the court makes a ruling on whether or not that evidence is sufficient. But if you're saying we're not stipulating to the evidence that is being presented to the court, then she's not even stipulating to the fact that she's alleged to have committed a theft from the junior league.
I think we've got a clean copy of the paperwork, Judge, that we can.
All right.
Judge,
swap out.
if I may, we can't stipulate to the amount. So we would have at the very
That's why you have it. Nobody ever stipulates to an amount. That's why you all have contested hearings and I make a decision on whether or not they owe it or not.
And Judge, and I know we're getting in sort of ahead of ourselves, but I'm asking for the court to not order restitution to the third parties. I don't think that that's appropriate.
Well,
They
that's
have-
where you present evidence and I make a decision, or you present some kind of law and I make a decision on whether or not that amount that is below the line, because it's not a part of your agreement, then I make a decision on whether or not that amount should be paid or any amount should be paid to Visa or Berkshire.
And Your Honor, it's what I'm requesting the court to do is to not order that, so that can be handled in a civil court. They are set up for that. That's the way the normal course goes on these things. And it's going to be, we would need a forensic accountant to go through this. It's going to be a very long and arduous restitution.
I understand what everybody is saying. I want to let everybody know I'm internalizing what's being said. What I am telling the parties is this: if she's not stipulating to the evidence that's been presented by the state, that means she's not stipulating that she even committed a theft with the junior league. I don't know why she paid the amount to the junior league, because she's not stipulating to that. Things that are below the line, that means that it's contested. That means that I'll hear evidence. I'll make a decision on whether or not restitution should be paid to Berkshire or Visa. That's something that I will hear. The only thing you're allowed to do, I don't contest, is when they have in the plea paperwork where it has the indictment on or about whatever. That's like on or about whatever I judicially admit. You can scratch that out and you put, I'm not contesting anything. But for the stipulated evidence, the evidence is what's being presented. Otherwise, if you're not stipulating to any of the evidence, then there's no plea.
Judge, we're willing to stipulate to everything except the final
Then
amount.
you all need to change your paper.
And Your Honor, I know, to press a point on this, it's my understanding, my belief that the law allows us to not stipulate to true and correct. The judge has the evidence and the judge can look at that and decide that they find those documents credible and find that they are true, or
I can't do any of that if y'all are not stipulating to anything. Then everything is a challenge. So this is what I will tell y'all to make it simple. I'm not accepting this plea.
Okay, we'll redo the paperwork. Would you
All right.
accept if we just simply put on that we do not
y'all
stipulate to the final amount?
Y'all do the paperwork. And if y'all want to put in there that the final amount from Berkshire and Visa is contested, which to me, you've already said that. That's why it's below the line. If y'all want to do that, fine. But everything else, no.
And you understand that all the money was for the junior league, but they just filed an insurance claim and a Visa claim.
Here's the
There's
thing.
no
I haven't read any of the evidence. So I don't know what y'all are presenting because y'all haven't stipulated to anything. I don't know why there's an objection to outside the agreement. Everything that is outside your agreement is contested, and I'll hear evidence. This argument that you all are making on she doesn't owe to Berkshire, she doesn't owe to Visa, we haven't even got to that point yet because nobody stipulated to anything. And when things are below that line, that means that it's contested. That means I'll hear arguments. I'll hear whatever kind of law somebody wants to present me on whether or not you should be paying that under this cause number.
And Judge, the reason I am making this issue is because it says in the documents that higher amount. So we don't want to stipulate to that. So we'll change the document to say that and we'll reapproach.
Oh, y'all need to reprint that entire document out because that's been sworn to. She's been sworn to that specific document by the clerk. And if people start making changes to that document, it's no longer a sworn document.
We can do that, Judge.
Okay.
Thank you.
So, yes, so everything needs to be reprinted and redone. Thank you.
Thank you.
Yes.
All right, who's next? Anyone else ready? Brian Jimenez. Hello, good morning.
Just speaking with the prosecuting attorney, we are going to do pre-trial diversion.
Right, so your client needs to be up.
Yes, Your Honor, he's right here.
All right, Ms. Ferguson, I need a PTD, please. All right, you need to have all of the paperwork and everything filled out. Before November. All right.
Sure.
All right, once you sign the reset form, you're excused. Make sure you follow up on PTD, all right? All right, good luck to you.
Thank you, Your Honor.
You're welcome. All right, who's next? Kimberly Cuevas. All righty. All right, I need the plea paperwork for her. All right, are y'all still going to proceed with the plea?
We are, Your Honor.
All right. All right, the court is calling 2025 CR 008801 State versus Kimberly Cuevas. Could I have parties announced for the record for the state?
Rick Pena for the state of Texas.
Defense.
Jorge Canales for defense.
And are you Ms. Cuevas?
Yes, Judge.
All right, Ms. Cuevas. Where we left off, I believe on Tuesday, was I had gone over the plea bargain agreement with you. And according to the plea, there's a $1,500 fine. State is recommending deferred adjudication. They're taking in consideration 2025 PF 09696. There's an affirmative finding of family violence. There's to be no contact with Evelyn Reyna and Robert Reyna. Now,
This is a long-term consequence moment. An affirmative finding of family violence carries serious legal weight. Firearm restrictions, custody implications, and future case impact. The judge ensures there's no confusion about that. This isn't just about today's outcome. This follows you forward. Do most defendants fully grasp that gravity?
the sticking point for you was the affirmative finding of family violence. With an affirmative finding of family violence, you're not allowed to possess any weapons or ammunition. And with an affirmative finding of family violence, you're not allowed to be designated primary custodial parent. Did you understand?
Yes.
All right. And so it was the court's understanding. We had this conversation. The court gave you time to speak with your civil attorney.
Yes, Judge.
Did you have time to speak with your civil attorney?
Yes, Judge.
And did you have time to speak with your defense attorney here?
Yes, Judge.
All right. So do you understand fully what an affirmative finding of family violence will mean? That's either yes or no.
Yes, Judge.
All right. And knowing that, do you understand that to be your plea in this court?
Yes, Judge. Can I just ask for the no contact order against Robert Reyna changed to non-injurious?
No.
contact? Because we have
Because
children.
this is your plea bargain agreement. So what is in your plea bargain agreement is everything that's above the line. So according to the plea bargain agreement that you entered into, there's to be no contact with Evelyn Reyna and Robert Reyna. Did you understand that to be your plea?
Yes, Judge.
And defense, is that the plea?
It is, Your Honor.
State, is that the plea?
It is, Your Honor.
And knowing everything about the affirmative finding of family violence, knowing that the court, if the court follows your agreement, there's going to be no contact with Robert Reyna and Evelyn Reyna. Do you still wish to continue with the plea?
Yes, Judge.
All right. Did you review the waiver of appeal paragraph with your attorney? Did you understand it
Yes, Judge.
and sign it in both places?
Yes, Judge.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Judge.
Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 6 years. There be 200 hours of community service restitution. The BIPP, a TAP evaluation, follow all recommendations in parenting classes. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Judge.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Yes, Your Honor. At this time, state offers into evidence, State's Exhibit 1 with all attachments.
No objection, Your Honor.
All right, did you review the waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Judge.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Judge.
Did you understand by entering into this plea, the state would not be presenting any witnesses? Their witnesses would be in the form of just police reports. Did you understand that?
Yes, Judge.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, we'd ask the court to consider probating some of the fine and some of the community service hours due to the fact that the young children that she has to care for would take up some time.
All right. How old are your children?
I have a 6-week-old and a 3-year-old.
All right. And are you employed?
Stay-at-home mom.
So how are you supporting yourself?
I have savings from the beginning of the year, and then my parents are my biggest support system.
All right. So do you live with your parents?
No, I have my own place.
All right. So why did this happen?
There's always been history of domestic violence between my husband and I.
But I don't understand, how does the domestic violence between you and your husband result in an injury to a juvenile?
Well, I feel like he put her in the middle, but I have no.
What do you mean he put her in the middle?
During our altercation, she was in the passenger seat the whole time, and he opened the door and was trying to shove our son into the car. So he put her in the middle, and then I was upset. I don't have a good reason as why I went after her, but it was in the moment I was really upset. So.
All right, and how old is she?
At the time, she was 12.
Excuse me. Do you need a cough drop? No. You sure?
Yes.
Okay. All right. The court is going to sentence you to a $1,500 fine. That will be probated. The court will sentence you to 4 years deferred adjudication. Proof of employment within 60 days. No employment as a home health care provider or with minors. There's an affirmative finding of family violence. There's to be no contact with Evelyn Reyna and Robert Reyna. You'll need to find a third party for visitation. There's to be regular reporting by Zoom or in person, regular random UAs, 200 hours of community service restitution. 100 of those hours will be deemed satisfied upon completion of parenting classes. The remaining 100 hours will be deemed satisfied once you complete BIPP. There's going to be field visits one time per month for 6 months. All right. Was there any alcohol or drugs involved in this?
Just marijuana.
All right. When's the last time you used marijuana?
That day, March 13th, 2025.
So if you're drug tested today, is it going to be clean? All right. There's going to be a TAP evaluation, follow all results. Follow all recommendations.
Can I say something?
Yes.
I've already completed parenting classes.
All right, you'll need to provide that to probation.
Oh.
Okay. Is there anything else that's needed, probation? Is there anything else you need from the court to be successful?
No, thank you.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Judge.
All right. Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, Judge.
All right, we can go off the record.
And the closing remarks shift the focus beyond punishment. The judge emphasizes responsibility, especially when children are involved. This becomes bigger than probation terms or fines. Courtrooms don't just assign consequences. They sometimes force reflection.
So here's the thing. When children are involved, adults need to think with clear heads, right?
Yes, ma'am.
Because the 12-year-old doesn't need to be involved in this, right?
Yes.
Your younger children don't need to be involved in this as well. So I know there's a parenting app. That's what they're probably going to have you all use to communicate. And probation, if on the civil side they want them to communicate through the parenting app, I will allow contact with the father of the children, but it has to be through the app. It's still not in person, okay?
Yes, ma'am. Thank you so much.
You're welcome. And there'll still be no contact with Evelyn, though.
Oh, that's perfectly fine.
Okay. All right, good luck to you.
Thank you, Judge.
You're welcome.
Thank you, Ann.
You're welcome. Ms. Madura, just give us a moment. You all have put on here that you're contesting the total amount owed for restitution. You're not, because you all agreed that she owed the amount to the junior league. Am I right?
Right.
So that's not contested.
Right.
So
Judge,
if
I
you want
may?
to put that in there, you need to put specifically what you're contesting. If you're contesting the insurance company, then you should put the insurance company in there. Otherwise, you're saying you're contesting
Judge, may
your
I
league.
address it?
Sure.
Because I'm the one doing this, not
Okay.
Chandler. So, Judge, what we're contesting is just the final total amount that are in the documents that are contained in State's Exhibit 1. And so that's what I'm trying to put on there, that we're contesting the total amount that they're saying is owed.
So you're contesting the amount that they're saying is
We're
owed
saying
to
it's-
Berkshire Hathaway and Visa?
Yes, indirectly. I mean, in the documents, Judge, in the State's Exhibit, it has that she owes, that the total amount for the funds that were taken were 11,000 something. Okay. We agreed to make a payment of the 1,077.01 upfront, but we have never, and we don't want to in the paperwork to stipulate that the 11,000 number that's in the State's Exhibit documents is a correct number. We believe it's lower. So that's the only issue. And Judge, and the reason why I'm I want to have this in the paperwork is because if we're requesting that you not order a restitution hearing and let the third parties handle that on the civil side, where they can get accountants and they can really dig into that. And so if we stipulate to the true and correct nature of all of the state's exhibits, that includes that 11,000 number. And on the civil side, then there's nothing for them to, have accountants come in and.
So this is what I'm telling you all. When you say you're not stipulating, you're stipulating to everything but the amount, you're including the amount to the junior league in that. If you want to put in there
Okay, I can.
something else to address that, you can put that in there. But when you all say you're not stipulating to any amount, then she's not even stipulating to the junior league amount.
Okay. We can put in there to owe to third parties.
Well, the junior league is a third party.
Well, the junior league is the complainant. They're not a third party.
What I'm telling you is the parties are the state and the defense.
Right.
Well, your client, the state and your client. The junior league technically is a third party. So whatever is in there that you all are not stipulating to, which it appears to the court from your plea bargain agreement, the only thing you're not stipulating to is the amount to Berkshire and the amount to Visa.
Yes, Your Honor.
Is that correct?
Yes.
So
And
why
that's
is it?
below the line anyway.
So why is it hard to put in there? We are not stipulating to any amount owed to Berkshire or Visa. Why can't that be added if that's the total amount?
I can do that, Judge.
Okay. Thank you.
Thanks, Judge.
Do you want us to print this out again, or can I just change the language?
You'll have to write it in there and then have her re-sworn by the clerk. All right. Anyone else ready?